Welcome to this month's Hot Topic presented by the NAMWOLF IP Pack. Today our presentation is Prosecution Laches. The defense still lurks, like the submarine patents it addresses. Today your presenters are going to be me, Lawrence Kass from Culhane, Meadows.
And me, Lisa Jakob from Merck & Co. Inc.
Our agenda today will be first to have an overview of submarine patents and the defense of prosecution laches. We're going to talk about two recent cases. Lisa is going to talk about a life science case, which she was personally involved with. And finally, we'll wrap up by talking about the impact of GATT on submarine patents and prosecution laches, and whether there is still a potential for submarine patents and the defense after GATT. So, what is a submarine patent? We look at it as a patent that's intentionally delayed in the patent office so it can lurk beneath the surface for a long time until it emerges and surprises the relevant market. And what is prosecution laches? Well, it's a defense against submarine patents, and it's an equitable defense, and its elements are unreasonable and unexplained delay in prosecution accompanied by prejudice. First case we're going to talk about is Hyatt versus Hirschfeld. And Hyatt is the name of the inventor in that case. He filed 381 continuations from 11 applications in the GATT bubble. The 9 days leading to GATT's enactment on June 8, 1995 are called the GATT bubble because the Patent Office reportedly received over 50,000 applications, 1/4 of the entire year's projected filings. Applicants at that time were motivated to file before GATT's enactment so they could keep their patent applications pending longer under the pre-GATT provisions, where patent term was calculated based on the issue date. Patent terms for applications filed after that date would be limited to 20 years. That's why submarine patent applicants were egregious in filing so many applications in the GATT bubble. From 1995 through 2003, he filed approximately 115,000 amendments and 45,000 independent claims. In 2013, the PTO found that because of the number of claims and the complexity and repetition, it would take 532 years of examiner time to get through all of his applications. The Patent Office instructed him to select no more than 600 total claims, which seems totally reasonable, to pursue for each of the 11 specifications. The PTO rejected 4 of them under Section 103 and 112, and Hyatt sued in DC District Court under Section 142. The PTO moved to dismiss for prosecution laches, and the court ruled against the Patent Office, faulting its informal procedures and failure to police claim shifting, which is excessive amendments and things like where you take one claim that says one thing and make it say something completely different, so it's a totally new claim. The informal procedures were things where the Patent Office really tried to work with Hyatt to get Hyatt to narrow his number of claims and streamline prosecution. Did that for several years without success. The PTO ultimately appealed the district court's determination, and the Federal Circuit overturned the judgment. The court held that the PTO, first of all, can assert the defense of prosecution laches in a 145 action, even if it didn't previously issue rejections or warnings based on prosecution laches. The court also said that the district court failed to consider all the circumstances of Hyatt's conduct and delay and focused too much on the PTO's conduct, meaning the informal procedures that it tried to use to get Hyatt to narrow the prosecution and expedite it. The Federal Circuit found that there was unreasonable and unexplained delay of up to 28 years, and that included numerous filings of amendments with confusing priority claims, refiling claims previously lost, and interference in the amendment practices that we just mentioned. Turning to the issue of prejudice and intervening rights, the court didn't actually have facts because the PTO was the counterparty, not a private party that would have been prejudiced. But the court found that it could be presumed because of the delay of more than 6 years. Our second case is PMC versus Apple. And that was before the Eastern District of Texas, which is a pro-plaintiff jurisdiction, especially for tech cases. In that case, the PMC inventors filed their first application in 1981, prosecuted them serially until 1995, but then, leading up to the gap bubble, they filed 328 continuations at 600 pages each, claiming priority to just 2 applications, very similar to the Hyatt case. At one point, there was up to 20,000 claims pending, again similar to Hyatt. There, they also submitted identical claims and different applications at the same time. There was a jury trial, and maybe not surprisingly, in the Eastern District of Texas, PMC won a verdict of $308 million. There was a separate bench trial on prosecution Laches. Maybe more surprisingly, Judge Gilstrap reversed that $308 million verdict. He relied on Hyatt, but rejected the presumption in Hyatt because this case was not a Section 145 case. He said that an issued patent remains entitled to a presumption of validity. In a 145 case, you're dealing with a patent application. He also found that the delay in Hyatt was very similar to PMC's delay. Likewise, in both cases, the applications were long and complex. The number of claims ballooned after the applications were filed, and thousands of references of questionable relevance were disclosed to the Patent Office. He also said that the only rational explanation for PMC's approach to prosecution was a deliberate strategy of delay. He said there was clear evidence that Apple developed intervening rights and therefore was prejudiced during the period of delay. Specifically, nearly 10 years after PMC filed its application and years before the patents issued, Apple's tech, which was called Fair Play, it had matured into its accused version. To add insult to injury, while prosecuting the claims, PMC was actually negotiating with Apple for a license. In conclusion, Apple was prejudiced. The court found Laches and reversed the verdict.
So we'll now talk about an older case, but a goodie in my mind, and that is Cancer Research Technology versus Bar Labs. The party that you don't see up there on the screen is also Schering-Plough was involved in this case as well, and that was how I was involved because I was managing IP litigation for Schering-Plough through the merger with Merck. So the active ingredient for a cancer drug called Temodar was temozolomide, which is a tetrazine derivative. The original application was filed in 1982, and it identified 13 important compounds, including temozolomide and midazolamide. So those were the 2 lead compounds. And actually, midazolamide was the original lead compound that was pursued by Aston University and the May Company, which was later taken over by RPR, Rhone-Poulenc-Royer. And so in the first substantive office action in 1983, the examiner alleged a lack of utility. And back in the day, a lot of patent prosecutors used to call this the incredible utility rejection, wherein the examiner said that it was not a treatment for cancer, in this case leukemia, was not a believable utility on its face. And that was because during this time period, there were not a lot of treatments for cancer that had proved to be useful. During the prosecution, the examiner said that you can establish utility by clinical reports and data. Now, in the specification, there actually was anti-tumor activity that had been evidenced in mice. So there was some data in the application and should have been enough to prove the baseline for utility. But the examiner did not accept the anti-tumor activity in mice and rejected the utility. The applicants filed a continuation. The examiner, even after looking at the mouse data, continued and reinstated the rejection. This occurred 8 more times, and the patent eventually changed ownership in 1991 to Cancer Research, which is a charitable organization. Once Cancer Research took over the prosecution, they then challenged the utility rejection and again argued that the animal data that had been presented in the patent was sufficient to establish utility in humans. And that is because there is such a close link in cancer research from animal data to human data. You can extrapolate from that. And the Cancer Research and the PTO went back and forth on establishing the utility for humans through animal data. So as I mentioned earlier, midazolamide was actually the original lead compound, and it advanced from animal trials into human trials. But once it reached human trials, it showed to have some toxic side effects. So while it was actually active against cancer, it had too many side effects to be useful to be used in humans. Temozolomide then became the lead compound. And so throughout the 80s and into the early 90s, they were doing animal testing in both midazolamide and then human testing in midazolamide. And then they turned to animal testing and human testing in temozolomide. Temozolomide became the compound when it showed that it was safe and had anti-cancer activity. The claims were finally allowed in 1993, and the drug was eventually approved by the FDA in 1999. This led to 1,006 days added to the patent's term, but because of the 14-year cap, I don't think the patent got extended quite that far. Cancer Research sued Barr after it filed its ANDA in 2007. The district court, Judge Robinson, found prosecution laches due to the 11 continuations with no substantive prosecution for nearly a decade. But wait, there's more. The Fed Circuit reversed, finding that there was no prejudice in this case. And there were multiple reasons why there was no prejudice. The most clear, of course, is because Barr was a generic company. They were relying entirely on the work that Schering-Plough and Cancer Research had done in order to bring the drug to market. They themselves had not done any research on their own. And so there was no intervening period between the time of when the patent was originally filed and when the patent issued that Barr could claim any intervening rights. There also wasn't any prejudice because Cancer Research did not even get the full patent term extension that they would have been entitled to, as we mentioned earlier, over 1,000 days, because in the Hatch-Waxman scheme, there's a 14-year cap. And so the 14-year cap actually cut the patent shorter than what the actual extension would have been. And finally, the Fed Circuit noted that the facts of this case are not likely to be frequently repeated because after 1995, there's only a limited number of GATT cases that would be left. So here's why Larry really wanted me to join this call, to give you a little bit of background and added color about this case. So, as we patent litigators read cases, we read the texts and the context, and you don't really get to read between the lines and find out what what was really going on here? And so one of the things that I loved about working on this case is it was such a great example of the collaboration between university, industry, and charity. So Aston University had originally worked with a subsidiary of Rhône-Poulenc-Royer to develop these compounds, these tetrazine derivatives. And along the way, because it was such a long journey, RPR lost interest in developing these tetrazine derivatives and ended up giving their rights to a charity, Cancer Research. And Cancer Research was very interested in continuing to do research in this area because they knew that there were anti-cancer properties of these compounds. And so they then found a partner in Schering to help them finish clinical trials and bring these drugs to market, this drug to market. So there were also some very interesting people who were involved in this case. The first of which was Malcolm Stevens, the lead inventor. So Malcolm was a university professor at the University of Aston, and by the time we were doing discovery in this case, he had moved on to the University of Nottingham. Now, Malcolm was quite a large figure in chemistry in the UK, and as a result of his discovery of these tetrazine derivatives and their application in the treatment of cancer, he was awarded many, many awards, which of course, for those patent lawyers out there, you know, is very helpful in your obviousness case. But what made his OBE very special was that Princess Diana was the one to hand it to him. So he was always very proud of that. And when I went to visit him for prep, he showed me the picture of he and Princess Diana and Prince Charles, who actually gave him the award. Then we also had another very interesting inventor, and that was Bob Stone. So Bob Stone, after working with Malcolm on this discovery that led to a treatment for cancer, quit chemistry altogether and essentially lives off the grid. He built a house that's completely geothermal and solar, and he no longer practices chemistry. Another inventor also quit chemistry, but not because he was so intimidated and by the greatness of their original accomplishment in treating GBMs, but because Dr. Woodbridge met his wife, who had been a dancer, and they didn't meet until they were in their 40s. And so when they did meet and got married, they decided that they'd already missed spending half of their life together, and they did not want to miss another minute together. And so he quit his job, she quit her job, and they spent all of their days together, so that when we went to go prep him for his deposition and for his deposition itself, each time we took a break, he would jump up and run out into the lobby of the hotel where all of these preps and depositions were going on. And his wife would be sitting there in her beautiful suit. And every day it was a different color, either blue or pink, as Larry has so graciously put a drawing up. And she would have a matching hat and a matching handbag and matching shoes. And they would just sit there holding hands in the lobby, chatting the entire time, every time he took a break. And I just thought that was such a wonderful story that all of you should hear about, because there are people behind these inventions, and some of them are really quite amazing. And one thing that I didn't mention was Malcolm, while he was quite a large figure in chemistry, and he actually gave away a lot of the money that he derived from this invention. So because he was a university professor, he actually got a cut of the sales revenue from these inventions. And while he wasn't required to do so, he actually gave a percentage to each of the people that worked in his lab, including Bob Stone, which I think allowed him to quit and live off the grid, but also he donated quite a large amount of his proceeds to charity as well. So he not only split it amongst the people that worked with him on the invention, but he also gave quite a bit of money to charity.
Thanks so much, Lisa. I love those stories. Each one's more heartwarming than the next. Now we're going to speak about the GATT impact on submarine patents. So we talked a little bit about that before, how the law changed from being the 17 years from issuance to 20 years from the date of the application. That change was actually partly responding to the problem of the submarine patents. And since then, courts have acknowledged that post-GATT applications are less likely to be submarine subject to prosecution laches. A more interesting question is, what will take the place of prosecution laches in submarine patents? Lisa and I were talking a little bit about this, and we were talking about 112 as the likely future challenge.
Right. I think, when you look at some of these submarine patents and, they're lurking there below the surface, and then you are able to later draft claims on your competitors' inventions once they have come to market, or once you sort of read an article to see what other folks are working on and can you adapt your claims to that. I think what we will likely see, instead of prosecution laches as a defense, and maybe you have both, would be a 112, or, a defense of written description or enablement, because I think when you're talking about something like the Hyatt cases, right, where 10, 15 years have gone by, the likelihood that you actually have support sufficient to overcome the new cases that have arisen in the last 5 years on 112 is probably very unlikely.
Right. So where does that leave us? Well, there's a narrow possibility that after GATT, there might still be submarine patents, and there might still be a need to apply prosecution laches, and several courts have actually noted that. Although there hasn't been any that actually came out and had a trial on it and ruled that there was prosecution laches that was applied to the submarine patents. Well, that's it for our presentation. We thank you for your attention, and we'd be happy to take any questions you may have.
Larry will be happy to take any questions you have.
About the tech cases.
Just kidding.
Anything on cancer research is up to Lisa. Thank you.